Senate roll call for day 14, Thursday, February 29th, Leap Day 2024. Anderson? Baldwin? Here. Barlow? Present. Beitman? Here. Boner? Here. Bouchard? Here. Brennan? Here. Case? Present. Cooper? Here. Dockstetter? Excused. Ellis? French? Here. Furphy? Here. Guru? Hicks? Here. Hutchings? Here. Ide? Here. Jones? Here. Kinski? Kolb? Present. Landon? Excused. Larson? Here. Guru? Here. McEwen? Here. Nethercott? Pappas? Here. Rothfuss? Here. Salazar? Here. Schuler? Here. Scott? Here. Steinmetz? Here. Anderson? Here. Kinski? Excused. President Driscoll?
Here.
28 present, 3 excused.
Prayer by Father Thomas Conkle Jr., St. Mary's Cathedral.
Let us pray. Lord God, we are well into the week, but it's only Thursday, not Friday. So we still have 2 full days before the weekend and an extra day to the month due to leap year. We have to accomplish much today and tomorrow before we can rest. Grace us, therefore, with your inspiration and comfort as we hear, discuss, amend, and vote on legislation. Let the words of King David assist us. The Lord is my shepherd, there is nothing I lack. In green pastures he makes me lay down, to still waters he leads me, he restores my soul. He guides me along right paths for the sake of his name. Even though I walk in the valley of the shadows of death, I fear no evil, for you are with me. Your rod and your staff comfort me. You set a table before me in front of my enemies. You anoint my head with oil. My cup overflows. Indeed, goodness and mercy will pursue me all the days of my life. I will dwell in the house of the Lord for endless days. Amen.
Senator Grew, lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Reading, correction, approval of journal.
Mr. President, your journal committee reports that the journal of February 28, 2024 has been read and recommends that it be approved. Senator Larson, chairman.
Any objections? Hearing none, the report is adopted. No doctor for the day. Our nurse for the day is Jennifer Gabriel, Cheyenne Regional Medical Center. Is she here? Don't see her, but she'll be around if you have problems. Today in Wyoming history, in 1912, the Wyoming Tribune published the names of eligible bachelors for the benefit of matrimonially inclined women. Things like this were surprisingly common at the time. The publication on this date was not accidental, as this particular day was associated with Sadie Hawkins type events. Quote for the day: leap year is a reminder that sometimes a little extra time is all we need to make a big difference. Happy Leap Day to you. Signing of enrolled acts. In other words, coffee break. We're at that order of business, signing of enrolled acts. Senate Enrolled Act number 4.
Senate Enrolled Act number 4, being original Senate File 3. State Employee Leave for Volunteer Emergency Service, an act relating to the administration of government.
I am about to sign Senate Enrolled Act Number 4, originally Senate File Number 3. I have so signed. Senate Enroll Act Number 5.
Senate Enrolled Act Number 5, being original Senate File 30. Influencing jurors and witnesses, judges' amendments, an act relating to crimes and offenses.
I am about to sign Senate Enrolled Act Number 5, originally Senate File Number 30. I have so signed. Enrolled Act Number 1, House of Representatives.
House Enrolled Act Number 1, being original House Bill 73, Abandoned Mine Reclamation Accounts, an act relating to environmental quality.
I'm about to sign House Enrolled Act Number 1, originally House Bill Number 73. I have so signed. House Enrolled Act Number 2.
House Enrolled Act Number 2, being original House Bill 72, Workers' Compensation Provision for Adverse Deviation, an act relating to workers' compensation.
I'm about to sign House Enrolled Act Number 2, originally House Bill Number 72. I have so signed. House Enrolled Act Number 3.
House Enrolled Act Number 3, being original House Bill 71, Broadband Development Subaccount Amendments, an act related to economic development.
I'm about to sign House Enrolled Act Number 3, originally House Bill Number 71. I have so signed. House Enrolled Act Number 4.
House Enrolled Act Number 4, being original House Bill 46, Chancery Court Timeline for Resolution of Disputes.
I'm about to sign House Enrolled Act Number 4, originally House Bill Number 46. I have so signed. House Enrolled Act Number 5.
House Enrolled Act Number 5, being original House Bill 40, School District Trustee Oath of Office.
I am about to sign House Enrolled Act Number 5, originally being House Bill 40. I have so signed. House Enrolled Act Number 6.
House Enrolled Act Number 6, being original House Bill 27, DFS on Law Enforcement Reporting.
I am about to sign House Enrolled Act Number 6, originally being House Bill Number 27. I have so signed. House Enrolled Act Number 7.
House Enrolled Act Number 7, being original House Bill 26, Emergency Protective Services Effective Period.
I am about to sign House Enrolled Act Number 7, originally being House Bill 26. I have so signed. House Enrolled Act Number 8.
House Enrolled Act Number 8, being original House Bill 23, Vehicle Registration, E-Certificate, and Grace Period, an act relating to motor vehicles.
I am about to sign House Enrolled Act Number 8, originally being House Bill Number 23. I have so signed. House Enrolled Act Number 9.
House Enrolled Act Number 9, being original House Bill 21, Charter School Leasing, an act relating to K-12 school facilities.
I am about to sign House Enrolled Act Number 9, originally being House Bill 21. I have so signed. House Enrolled Act Number 10.
House Enrolled Act Number 10, being Original House Bill 16, Sutton State Archaeological Site Legal Description, an act relating to state lands.
I'm about to sign House Enrolled Act Number 10, originally being House Bill Number 16. I have so signed. House Enrolled Act Number 11.
House Enrolled Act Number 11, being Original House Bill 11, State Land Lease Amendments, an act relating to state lands.
I am about to sign House Enrolled Act Number 11, originally being House Bill 11. I have so signed. Senator Nethercott.
Privilege of the floor.
Granted.
Thank you, Mr. President. Good senators. If you could please look straight ahead into our gallery. We are joined this wonderful morning with the Wyoming Youth Advisory Council. They are students from around the state advocating for our foster care system. And you can see we also have the honor of the attendance of the First Lady, Jenny Gordon, who is taking care of them today. If we could give the First Lady and these talented students from across our state a warm Senate welcome.
There. All right. House Enrolled Act Number 12.
House Enrolled Act Number 12, being Original House Bill 10, Grace Period State Land Lease Renewals.
I am about to sign House Enrolled Act Number 12, originally being House Bill Number 10. I have so signed. Senator Jones.
Mr. President, privilege of the floor. We have Sweetwater County School District Number 1 today viewing us. We have Kelly McGovern, our superintendent. We have 2 of our school board members, Stephanie Thompson, Carol Jellicoe, and our facilities director, Dan Celeroli. Please welcome them.
House Enrolled Act Number Lucky 13.
House Enrolled Act Number 13, being Original House Bill 8, Commercial Driver's License Hazardous Materials Endorsement, an act relating to motor vehicles.
I'm about to sign House Enrolled Act Number 13, originally being House Bill Number 8. I have so signed. Senator Cooper.
Privilege of the floor. Thank you, Mr. President. We got a pretty rough and tumble bunch of guys over here on the right side I'd like to recognize from all over the state. I'm sure there's one up there from your district. It's our chiefs and sheriffs. If you gentlemen stand up so we can recognize you and say thank you for being here.
Messages from the House.
From the House of Representatives, February 28, 2024, message number 187. Mr. President, the House did concur on Senate amendments to House Bill number 14, Prior Authorization Regulations, ayes 61. Message number 188. Mr. President, the House appointed House conferees to meet with a like committee number 1 from the Senate on amendments to Senate File 20. House conferees are Representative Olson, Chairman, Representative Harrelson, and Representative Wiley. Message number 189. Mr. President, the House appointed House conferees to meet with a like committee number 1 from the Senate on amendments to Senate File 2. House conferees are Representative Zwanitzer, Chairman, Representative Stiff, and Representative Yin. Signed, Katie Talbot, House Chief Clerk.
Thank you. House bills on first reading. House Bill 60, first reading of the House bill.
House Bill 60 engrossed, Excess Wildlife Population Damage Amendment, sponsored by the Agriculture Committee, an act relating to game and fish, passed the House, ayes 43, noes 18, excused 1.
House Bill 60 is referred to Committee Number 6, Travel. For your edification, that leaves the drawer empty in my office. Back to signing of enrolled acts. Enrolled Act, House Enrolled Act number 14.
House Enrolled Act Number 14, being original House Bill 14, an act relating to the Insurance Code.
I'm about to sign House Enrolled Act number 14, originally being House Bill number 14. I have so signed. Reports from standing committees.
February 29, 2024. Mr. President, Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom was referred House Bill 126, engrossed. Child care is a residential use of property. Respectfully report same back to the Senate with the recommendation that it do pass amended. Ayes, Senators Barlow, Boner, Scott. No, Senator Case. Excused, Senator Landon. Senator Case, Chairman. February 29, 2024, Mr. President, Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 43, State Forestry Good Neighbor Positions. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators French, Hicks, Kolb, Larson, and Steinmetz. No, Senator Ide. Senator Steinmetz, Chairman. February 29, 2024, Mr. President, Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 36 engrossed, Natural Resource Protection Act. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators French, Hicks, Ide, Kolb, Larson, and Steinmetz. Senator Steinmetz, Chairman. February 29, 2024, Mr. President, Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 93 engrossed, Animal Reimbursement Program Account Amendments 2. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators French, Hicks, Ide, Kolb, Larson, and Steinmetz. Senator Steinmetz, Chairman.
Thank you, Randy. Bills on second reading. House Bill 9, second reading of the House Bill.
House Bill 9, Fuel Tax Licensee Information Deadline.
House Bill 9 having been read 2 separate times. The question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 20, second reading of the House Bill.
House Bill 20, School Finance Regional Cost Adjustment Study.
There is an amendment. Could we have the amendment read in, please?
House Bill 20, second reading amendment number 1, page 2, line 23, after.
Senator Hicks. Second reading amendment number 1 on House Bill 20.
Mr. President, I've moved second reading amendment number 1 to House Bill
20.
20, excuse me. So, Mr. President, this just goes in the section where we're going to start tracking the amount of mileage between school buildings. And it's just that if we're going to track the amount of mileage, it may be of pertinent information that we want to know what all that travel is for. It just brings in the language is for the purpose of what that travel is for. So that's all it does, just adds to collect a little more data so we know why this travel is going from school building to school building or from school district to district. That's all it does.
Thank you. Further questions? Further questions? Senator Rothfuss.
Thank you, Mr. President. Mr. President, that may not be as easy as it seems. The aggregate travel was actually based on the idea of when working on a regional cost adjustment, how far people are from various destinations. So trying to get an understanding of the travel the mileage base is a simple number to report. The what were you doing when you were traveling is a much more onerous report. One of the interests, I think, of the Education Committee was, as we were contemplating these data requests, was trying to keep them down as non-disruptive as we could get them to be, so that they would be easy data sets that could just be provided, as opposed to, that would be available, readily available, as opposed to new generation of information requests. And honestly, I don't know if they are keeping track of all of the destinations for all of the travel as is suggested. So it seems reasonable, but it might not be as easy as it seems. And I guess I'm a little bit worried about just putting that in there and then creating a new data gathering, which might be interpreted as, every piece of travel that happens, we need to know where that's going. So is that the interest, or is it more like this is for school bus route, this is for personal travel, or do we really want to know the destination of every trip for all of the school days of the year? I'm a little worried about that aspect, Mr. President, so curious about it.
Senator Scott.
Mr. President, on and for the amendment, I think that if a State Department will use a little common sense in collecting the data, that it can be put into probably half a dozen different categories, and that will give us some useful information. If the bureaucrats decide to just dump the file cabinet and tell us about every trip, that won't work, but I think a little common sense in it will, Mr. President, so I'm supporting the amendment.
Further comments? Further comments? We're voting on second reading amendment number 1 to House Bill 20. All in favor say aye. Aye. Those opposed, no. Ayes have it. Second reading amendment number 1 to House Bill 20 has passed. We're back on the bill. House Bill 20 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 31, second reading of the House bill.
House Bill 31, Peace Officers, Records and Reporting.
House Bill 31 having been read 2 separate times, the question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 64, second reading of the House bill.
House Bill 64, Fire Prevention and Electrical Safety Amendments.
House Bill 64 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 67, second reading of the House bill.
House Bill 67, engrossed, Outdoor Recreation and Tourism Trust Fund Administration 2.
House Bill 67 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 70, second reading of the House bill.
House Bill 70, engrossed, Local Government Distributions.
House Bill 70 having been read 2 separate times, the question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 83, second reading of the House bill.
House Bill 83, engrossed, Public Retirement Actuarially Determined Contributions.
There is an amendment. Could we have the amendment read in, please?
House Bill 83, second reading amendment number 1 to engrossed copy, page 1, line 7, delete.
Senator Anderson.
Mr. President, I move second reading amendment to House Bill 83. This is just a technical correction. The staff realized that they had to change that. They left section 3 as an effective date of 2026, but they moved section B there to July 1st, 2024, and that's all this does. Thank you. Mike.
We're voting on second reading amendment number 1 to House Bill 83. All in favor say aye. All those opposed, no. Second reading amendment number 1 to House Bill 83 is passed the Senate. House Bill 83 having been heard 2 separate times, the question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 86, second reading of the House bill.
House Bill 86, Vehicle Lien Amendments.
House Bill 86, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 138, second reading of the House bill.
House Bill 138, State Funds, Pool A Participation and Fund Limits.
House Bill 138, having been read two separate times, the question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 148, second reading of the House bill.
House Bill 148, engrossed, Regulation of Surgical Abortions.
House Bill 148, having been read two separate times, the question is, shall the bill be heard a third time? Hearing no objection, it is so ordered. House Bill 197, second reading of the House bill.
House Bill 197, engrossed, State Sales Tax Administration revisions.
House Bill 197 has been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Bills on third reading and final passage. Mr. Majority Floor Leader, do you have a consent list? Not here, okay. We'll stand at ease to the sound of the gavel. We're short of Majority Floor Leader. We're fine. Bills on third reading, final passage. Mr. Majority Floor Leader, do you have a consent list?
Mr. President, we do have a consent list, and the consent list is as follows. House Bill 12, Wyoming Dairy Marketing Act, repeal. House Bill 13, flow-through pool exemptions. House Bill 15, health insurance reimbursement of overpayments. House Bill 25, Medicaid third-party payer conditions. House Bill 33, mining operations, blasting requirements. House Bill 34, solid waste municipal cease and transfer funding. House Bill 35, limitations on environmental rulemaking. House Bill 54, Wyoming Reads Day. House Bill 66, firefighter cancer screening benefits. House Bill 74, public health nursing, budget requests, and House Bill 81, public officer training amendments.
Would anybody like any bills removed from the consent list? Having been read 3 separate times, the question is, shall these bills pass the Senate? House Bill 12, Wyoming Dairy Marketing Act, repeal. House Bill 13, flow-through pools exemption. House Bill 15, health insurance, reimbursement of overpayments. House Bill 25, Medicaid, third-party payer conditions. House Bill 33, mining operations, blasting requirements. House Bill 34, solid waste municipal cease and transfer funding. House Bill 35, limitation on environmental rulemaking. House Bill 54, Wyoming Reads Day. House Bill 66, firefighter cancer screening benefits. House Bill 74, public health nursing budget requests. And House Bill 81, public officer training amendments. The Chief Clerk will call the roll.
On the consent list, Anderson. Baldwin. Barlow. Beitman. Boner. Bouchard. Brennan. Case. Cooper. Dockstader excused. Ellis. French. Murphy. Guru. Hicks. Hutchings. Ide. Jones. Kinski. Kolb. Landon excused. Larson. McEwen. Nethercott. Pappas. Rothfuss. Salazar. Schuler. Scott. Steinmetz. President Driscoll. On the consent list, 29 present, 2 excused. House Bill 12, are there any changes? Closing vote. Closing. Vote closed. House Bill 12, 29 aye, 2 excused. House Bill 13, are there any changes? Case I to know. Closing vote. Closing. Vote closed. House Bill 13, 28 aye, 1 no, 2 excused. House Bill 15, are there any changes? Closing vote. Closing. Vote closed. House Bill 15, 29 aye, 2 excused. House Bill 25, are there any changes? Closing vote. Closing. Vote closed. House Bill 25, 29 aye, 2 excused. House Bill 33, are there any changes? Closing vote. Closing. Vote closed. House Bill 33, 29 aye, 2 excused. House Bill 34, are there any changes? Closing vote. Closing. Vote closed. House Bill 34, 29 aye, 2 excused. House Bill 35, are there any changes? Case aye to no. Hutchings aye to no. Closing vote. Closing. Vote closed. House Bill 35, 27 aye, 2 no, 2 excused. House Bill 54, are there any changes? Aye. Aye to no. Larson? Aye to no. McEwen? Aye to no. French? Aye to no. Closing vote. Closing. Vote closed. House Bill 54, 25 aye, 4 no, 2 excused. House Bill 66, are there any changes? Case aye to no. Closing vote. Closing. Vote closed. House Bill 66, 28 aye, 1 no, 2 excused. House Bill 74, are there any changes? Aye. Aye to no. Larson? No. Closing vote. Closing. Vote closed. House Bill 74, 27 aye, 2 no, 2 excused. And lastly, House Bill 81, are there any changes? Case aye to no. Nethercott, aye to no. Ellis, no. Closing vote. Closing. Vote closed. House Bill 81, 26 aye, 3 no, 2 excused.
Having received the affirmative vote of the majority of members elected to the Senate, House Bill 12, Wyoming Dairy Marketing Act repeal, House Bill 13, flow-through pools exemption, House Bill 15, health insurance, reimbursement overpayments, House Bill 25, Medicaid, third-party payer conditions, House Bill 33, mining operations, blasting requirements, House Bill 34, solid waste municipal cease and transfer funding, House Bill 35, limitation on environmental rulemaking, House Bill 54, Wyoming Reed's Day, House Bill 66, firefighter cancer screening benefits, House Bill 74, public health nursing budget requests, and House Bill 81, public officer training amendments have passed the Senate. Bills on third reading. House Bill 32, third reading of the House bill.
House Bill 32, Geologic Sequestration Unitization Amendment, sponsored by the Minerals Committee, an act relating to environmental quality.
There is an amendment. Could we have the amendment read in, please?
House Bill 32, third reading amendment number 1, delete.
Senator Rothfuss.
Thank you, Mr. President. Mr. President, without objection, I would remove third reading amendment number 1 to House Bill 32.
Without objection, third reading amendment number 1 to House Bill 32 is withdrawn. There is a second amendment. Could we have it read in, please?
House Bill 32, third reading amendment number 2, delete.
Senator Beitman.
Thank you, Mr. President. I'll move third reading amendment number 2 to House Bill 32 and ask for your favorable consideration. Ladies and gentlemen, third time's a charm here. I think we got this where it needs to be. Appreciate the good minority leader's help on this. We worked together on this amendment. We got the language crafted to where I think is a good landing spot to take care of the idea that I had to make sure that it's in statute, that the mineral estate remains the dominant estate, sticking with tradition, and also to not prohibit a mineral interest owner from being able to develop their minerals above or below the sequestration zone. So I think this accomplishes everything we're trying to do here, and I'll ask for your aye vote.
Further discussion. Seeing none. We're voting on third reading amendment number 2 to House Bill 32. All in favor say aye. Aye. Those opposed, no. Third reading amendment number 2 to House Bill 32 has passed the Senate. We are back on the bill. Is there any discussion? Seeing none. House Bill 32, having been read 3 separate times, the question is, shall House Bill 32, Geologic Sequestration Unitization Amendments, pass the Senate? Chief Clerk will call the roll.
House Bill 32, third reading roll call. Anderson? Aye. Baldwin? Aye. Barlow? Aye. Beitman? No. Boner? Aye. Bouchard? No. Brennan? Aye. Case? Aye. Cooper? Aye. Dockstader excused. Ellis conflict? French? No. Furphy? Aye. Garou? Aye. Hicks? Aye. Hutchings? No. Ide? No. Jones? Aye. Kinski? Aye. Cole? Aye. Landon excused. Larson? No. McEwen? No. Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar? No. Schuler? Aye. Scott? Aye. Steinmetz? No. President Driscoll? Aye. Closing vote. Closing. Vote closed. House Bill 32, 19 aye, 9 no, 2 excused, 1 conflict.
Having received the affirmative vote of the majority members elect the Senate, House Bill 32, Geologic Sequestration Unitization Amendments, has passed the Senate. Mr. Majority Floor Leader. Senator Beitman, thank you.
Thank you, Mr. President. Before we go into committee of the whole here, without objection, I would ask that House Bill 134, Property Tax Deferral Program Amendments, be re-referred from Revenue to Committee Number 1, Judiciary.
Without objection, so ordered. Senator Steinmetz.
Thank you, Mr. President. Without objection, I would ask that House Bill 104, Omnibus Water Bill Planning, and House Bill 43, State Forestry Good Neighbor Positions, be re-referred to Committee Number 2, Appropriations. There are appropriations.
Without objection, so ordered. Mr. Majority Floor Leader Hicks, we're at that point of business consideration of bills on general file.
Mr. President, can we stand at ease to the sound of the gavel? We're having a little technical difficulty for me to get those arranged in the consent, or into the general file.
We will stand ease till the sound of the gavel. Thank you.
So Sherry, can you get this state forestry good neighbor?
Reports from standing committees.
February 29, 2024. Mr. President, Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 116 engrossed, staged grouse implementation notice to landowners, respectfully report same back to the Senate with the recommendation that it do pass amended. Ayes, Senators French, Hicks, Ide, Kolb, Larson, and Steinmetz. Senator Steinmetz, Chairman.
Mr. Majority Floor Leader, with that order of business, consideration of bills on general file.
Mr. President, I move the Senate resolve itself in the committee of the whole.
You've heard the motion. All in favor, say aye. Aye. Those opposed, no. Senator Ide, did you come get your debt clock away from me, or did I give it? Okay.
The Committee of the Whole will please come to order. The first bill for our consideration is House Bill 36. Will the reading clerk read in the bill?
House Bill 36, engrossed, Natural Resource Protection Act, sponsored by SSFarm, an act relating to protection of constitutional rights.
You have heard the reading of the bill. What is your pleasure? Senator Steinmetz.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation House Bill 36 do pass. And for an explanation of the bill, I call on the good chairman of the Natural Resources Committee.
Senator Boner.
Thank you, Mr. Chairman. Senators, what we have here is House Bill 36. This is a product of your Select Federal Natural Resource Management Committee's interim work. And as many of you had the opportunity to hear, we heard quite a bit about some resource management plans that caused quite a stir in different parts of our state. Part of those published proposed management plans include references to shutting down large amounts of public access in parts of our state. And so this led to a discussion. We heard testimony in our committee about local sheriffs who made a very clear statement that if that were to be the case, that they would no longer cooperate with federal law enforcement in enforcing those new rules and regulations. And so that is the impetus behind this bill, which would give clear direction to our chief executive with the advice of the Attorney General, of course. And really the meat of the bill is on page 3, if you want to turn there, that any executive order, final rule, or regulation of the federal government that does not comply with federal laws, in this case, for example, multiple use mandate, simply saying that, I imagine there'll be litigation, it's a separate issue, but in the meantime, we're going to simply not help them out with our local resources or anything that is supported by the state of Wyoming, which includes oftentimes your local county sheriff. So that's a basic policy decision. It's a very clear statement that if for some reason they cross that line, that there's going to be this specific consequence, or this is at least a tool in our chief executive's tool belt. Some sideboards on the page 3, the governor will not revoke a valid primacy agreement. We like those. We don't want to affect those. And nothing in this act on page 4 will interfere with legitimate law enforcement activities, such as working to combat drug trafficking, human trafficking, those sorts of things, which we work with our federal partners with all the time. So this is focused specifically on natural resource issues, nothing else. I think it's very clear that we do have to make this very obvious statement. And I have to say, I think that we're in a much better spot than we were even a few months ago, due to the efforts of many of us on this floor. Some of these efforts have been a little bit more strict, like you see here. Others have been very productive, conciliatory, and have all led us to where we're at right now, which I think is a much better place. I hope that this never has to be used. I think we're moving in the right direction. But nevertheless, I think that this is a useful tool to have in our chief executive's tool belt to make sure that those more conciliatory efforts are given their due diligence. So that being said, I'll stand for any questions on this bill.
Any discussion? Senator Ellis.
Thank you, Mr. Chairman. I just wanted to offer just a counter, and I would agree with the bringer of the bill that this is in a lot better shape than how it was worked and originally presented in the interim. But just a thought, I just put away my document, hold on a second. I think my concern about it, though, really is just how it fits with existing processes. Right now, if you have a federal agency that in this particular case, we've talked a lot about the Rock Springs Management Plan. Once that decision is made final, the federal agency will issue something called a record of decision, and at that point, anybody can bring a lawsuit. And if the BLM continues on its path of ignoring Wyoming concerns, I suspect that a lawsuit would be filed fairly rapidly. You would likely see a motion to enjoin the federal agency from starting to implement their decision. And if they make a good faith argument and the court agrees, then the status quo remains until the litigation's resolved. And so all of that, to me, Mr. Chairman, happens in court. The arguments that would likely be raised would be a violation of the Administrative Procedures Act, the National Environmental Policy Act, and other federal land management policy acts. And so there's a lot of tools in that tool belt already. So I think that process exists right now. And this one, I think, just kind of muddies the water a little bit because it says upon a determination by the governor. Well, what if the governor determines something, but the federal courts don't? And so there might be some confusion out there where we're putting our people, our local law enforcement and some of the other individuals in a bit of confusion if we don't issue consistent directives. So that was my concern with the bill. I think it's in a much better place, as I mentioned, but I just wanted to offer that opposing view and why I voted no on this particular piece of legislation during the interim. Thank you.
Thank you. Senator Rothman.
Thank you, Mr. Chairman. Mr. Chairman, before I speak on the bill, may I have the privilege of the floor briefly?
Yes, you may.
Thank you, because I wanted to point out up in the gallery that we've got some students, 5th graders through 7th graders from the Laramie Christian Academy here visiting us today. If they would all stand up. So these are some of our great students from over across the mountain, and I'd like the Senate to welcome them and give them a nice round of applause. And now, Mr. Chairman, if I may, back on the bill.
Yes, Senator Rothman.
Thank you, Mr. Chairman. Mr. Chairman, the concern I have with the way this is drafted comes down to primacy and how hard we work to get it in many areas. Air quality, land quality, primacy as an agreement state with the NRC, primacy over Class 6 wells. This is one of the pride and joys, I would say, of our operations in the state of Wyoming, is how many different areas that we, the state of Wyoming, have taken over the regulation of many federal acts, and it takes a lot of work to do that. And it's always just one action away from not having that primacy, which would be very damaging to the people of the state of Wyoming. So I'm envisioning a circumstance where, for example, we're in a disagreement over an air quality issue, and we rule one way, in our opinion, the feds rule another way. It's going to go to court, and we say, all right, well, we're going to stop enforcing that. Mr. Chairman, at that point, my expectation would be it would be the full legal right of the Environmental Protection Agency to say, all right, well, we're going to take away primacy. If you won't enforce the laws and the rules and the regulations, then we'll do it for you. And I can't imagine a worse outcome for our energy sector, our ag sector, our minerals. It would be truly catastrophic for the state of Wyoming to lose sovereignty in any of the areas where we have fought hard to get it, because our Department of Environmental Quality does an exceptional job with permitting and regulation, and it is a real asset for the state of Wyoming to have such great people working on our behalf right here in the state that know the state of Wyoming. So these types of pieces of legislation, they sound good because we want to shake our fist at the feds when we're not agreeing with them. But Mr. Chairman, I'm worried what happens when they shake their fist back and we end up suffering as a result of it, right? We have the judicial process that was laid out by the good senator from here in Laramie County, where I would expect lawsuits to be filed if we had a significant disagreement. Those lawsuits could lead to an enjoinment of the enforcement of the rule if there is clear cause to do so, and it looks like we would have the likelihood or the potential likelihood of prevailing. So I feel like the judicial remedy is sufficient, and that legislation like this is really just going down that path of a non-constructive fight with the feds that I don't think helps anyone. So I have those concerns.
Senator Cole.
Oh, thank you, Mr. Chairman. Maybe I'm on the wrong bill here, but the way I read the bill, I don't quite see it in the same way. This gives the governor, the attorney general, the question: do they comply with the federal rules? And let me bring back everybody to the point that kind of brought this about. It was about the BLM in this case enforcing rules and laws in my county, Sweetwater County, and in fact ticketing people and doing something they had never done in the past. The question came up during this committee meeting. Our sheriff from our county got on there and stated publicly he will not aid the federal government in these actions. In other words, no jail to keep the folks in, no assistance when it comes just for this kind of thing. It's specifically stated it's not going to, affect say a drug task force or anything like that. He wasn't going to cooperate. And this was a tool that was developed in codifying that and giving the governor the choice. So this isn't about taking over primacy with the EPA or any such thing. This is purely about regulations that are concocted by some sort of non-congressional action, not law, that we disagree with. And our governor is really the one driving this train. It's a tool to say that, no, we're not going to cooperate, much the same as the gun protection bills said, that we aren't going to have cooperation. They can still do what they want to do. They can still arrest you. They can still put you through federal court. None of those things changes. We don't have any authority over that. We're just not going to help on and for this bill, Mr. Chairman.
Thank you. Senator Hutchings.
Thank you, Mr. Chair. I think this bill brings about the stock rails, which kind of screwing them down in the pickup truck to preserve the powers that were given to us by our founders. President James Madison said the powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concerns the lives, the liberties, and the properties of the people, and the internal order, improvement, and prosperity of the state. We have a right to do this. We shouldn't be afraid of the federal government. That's all I have to say, Mr. Chair.
Thank you.
On and for the bill.
Senator Rothfuss.
Thank you, Mr. Chairman. Well, I do think I'm on the right bill, and I think we're even on the same bill. But it's not quite as flexible as was described, where there's that discretion. There is the initial discretion, you see in the A paragraph, upon determination by the governor, with the advice from the Attorney General that an executive order, final rule, or regulation of the federal government does not comply with federal laws regarding federal land management, and upon providing notice. Now, here's the big shall clause. This state and all political subdivisions of the state shall not use any personnel funds appropriated by the legislature or any other source of funds that originate within the state of Wyoming to enforce or administer that federal executive order. That's not very flexible. So it was described as this great flexible concept where we have the ability to pick and choose and to make sure that we're not taking on any additional risk and that we wouldn't potentially have problems with that primacy that we've worked so hard for. And then we have this shall clause that basically says, if we find this, if you pull the trigger on it, boom, we eliminate everything. Every department, every municipality, every sheriff, anyone that takes state funds all the way throughout the state has to comply. It doesn't sound quite as targeted and scalpel-like as the proponents have described. If that's the interest, then this can certainly be changed to the point where discretion is available. But Mr. Chairman, I guess the question I would ask on that is, what is preventing that scalpel-like approach from happening right now, where I'm pretty sure that the governor does not have to use his executive authority to carry out any of these types of things, and can even suggest, hey, this is something we don't approve of, don't spend resources on it, don't spend your time on it, and then could actually add the additional language unless it threatens primacy or unless you have concerns. So, Mr. Chairman, once again, this is a great shake your fist, but I don't know that it's well thought through. Chief executive already has all the flexibility that the chief executive needs in determining whether to carry out actions that support these federal actions that we disagree with. That exists now, to the best of my knowledge, and so I guess I would ask, what can't the chief executive do now in a scalpel-like way that this would empower them to do? And Mr. Chairman, on that point, I'm not sure what is notwithstanding here, because it's not saying, all right, obliviate the rest of statute where there's this obligation, because I don't think that statute exists. I don't know what this is doing other than sending a signal, and it's just one of those potshot signals that really doesn't help anything, but if it actually got used, it would probably only damage the state, Mr. Chairman.
Senator Boner.
Thank you, Mr. Chairman. So page 3, line 18, the governor shall not revoke a valid primacy agreement. So if there's something that's unclear about that, I'd look forward to a second reading amendment. I think that's pretty clear. As far as the scalpel discussion, it's limited to that federal executive order, final rule or regulation, lines 19 and 18. So it is a scalpel. It's not a all or nothing approach. So I hope that clears it up.
Any further discussion? Senator Roth.
Yeah, Mr. Chairman, just responding to that last point, it is clear that it says the governor shall not revoke a valid primacy agreement. That was not what I said was going to happen. The feds are the ones that revoke the valid primacy agreement. We don't really have say in that. We don't get to say, well, we choose not to revoke it. And I'm sure that piece of paper would be really valued with the federal agency that was revoking the primacy at that point in time. It's not up to the governor unilaterally, it's up to the feds. That's my concern, and that's what needs to be addressed.
Senator Cole.
Thank you, Mr. Chairman. So I'd like to just point out that people trust the governor, I guess, until they don't. Well, I trust the governor to make the right decisions, and I like to give him discretion to make the right decisions. And this is one more tool in the toolbox to make those type of decisions. I think we face a new day and age now dealing with the federal government and their, new interpretations take over federal lands that we all live with and enjoy, especially in my county. So on and for the bill. Thank you, Mr. Chairman.
Thank you. Senator Barlow.
Thank you, Mr. Chairman. So my question for the gentleman from Rock Springs is, you trusted your sheriff, and now we're going to take that trust away from the sheriff and place it in one person. So are we shifting, or do you think that your sheriff, in the example that was used earlier, still has that ability to say, no, I'm not going there? Or now have we conceded all of that to the chief executive of Wyoming? Thank you, Mr. Chairman.
Further discussion? Senator Cole.
Yeah, thank you, Mr. Chairman. Thank you for the question. Why would that diminish the sheriff's elected authority? What in there would stop the sheriff from making that choice that he made currently? Maybe someone could help me with that. I'd like to know, because obviously that would be a consideration, or something that can be amended out to be more clear and further as this bill progresses in amendments. Thank you, Mr. Chairman.
Senator Ellis.
Thank you, Mr. Chairman. Just a scenario. Suppose, there's a resource management plan that's out there, it's final, record of decision issued, the governor says, don't like it. No local assistant, no political subdivision can provide any assistance to manage those federal resources. Okay. Things aren't really settled in the court, and the federal government's like, well, this is a valid resource management plan. Now imagine some lightning strikes in a really dry area and you have a grassland fire situation There are federal agents out there who can put out the fire, but say it's a large fire and their resources are really limited. So they call their local fire, the local fire department and say, hey, can you provide any assistance? Because this will impact you. This is a checkerboarded area. And if we all work together to contain the fire right now, less damage for everybody. But the fire says, well, no, our governor made this proclamation. I can't provide any assistance. That's the kind of thing I'm concerned about. And I don't see the wiggle room in there. And so that's the concern. It's a practical on the ground concern. That was why I voted no. But I understand we're mad at the BLM. Thank you.
Senator Steinmetz.
Thank you, Mr. Chairman. Well, let me swat a few black helicopters away while we look at this good bill that I know we all heard a lot of issues over the interim on this. And if there needs to be a little tightening up, I'm sure that the good chairman and all of us would be willing to hear any of all the ideas. This is just simply getting everyone back on the same page of what the federal law is. So if it doesn't comply with the federal law, then we're saying the state's not going to enforce these new rules that don't comply with federal law, and we're weighing in on that. And so to me, it's a pretty simple solution. I think it's something we've done before regarding our gun rights and some other legislation that has passed through this body. And so if it needs tightening up, I'm sure everyone's all ears to find out some solutions to some things that have been raised. But I hope you'll put it through and keep working this good bill. Thank you.
Are you ready for the question? Yeah. All those in favor of Senator Steinmetz's motion that when Committee of the Whole rises to report, that it do so with a favorable recommendation of House Bill 36, say aye.
Aye.
Those opposed, no. No. The motion passes. The next bill for our consideration is House Bill 141. Will the reading clerk please read in the bill?
House Bill 141, State Land, Oil, and Gas Leases Operator Requirement, sponsored by Representative Western, an act relating to state lands.
You've heard the reading of the bill. What is your pleasure? Senator Cooper.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it does so with a favorable consideration of House Bill 141, State Land, Oil, and Gas Leases Operator Requirement. And to present this simple little bill for us is Senator Boner.
Senator Boner.
Thank you, Mr. Chairman. So House Bill 141 deals with a situation that has occurred a few times in recent history where you have oftentimes an NGO bidding on oil and gas leases for state lands, has no interest in developing those resources, or simply trying to increase the cost of doing business on our state lands. So, so the bill is an attempt to address that concern, that practice, and recognizing that if we're doing what's best for the trust beneficiaries, that probably includes developing a lease at some point, and we don't want to, be stepping over dollars to pick up pennies with a slightly higher bid. So what the bill does is that it offers a new procedure for the Office of State Lands that requires them to review the highest bid offer to determine that that bid offer is in fact a good faith offer from somebody who's willing and able to develop the lease. And if it isn't, they're going to go down to the second highest bidder and issue it to that and make sure that the lease actually goes to an entity that's going to be developing these state resources. Importantly, because we're concerned about making sure that we get as much as revenue as possible for the trust beneficiaries, the applicant whose bid was rejected will be subject to a civil penalty in the amount of the applicant's highest bid. So they're still going to have to pay that bid. And as a result, we're going to be doing what's right as far as our constitutional obligation to inure the greatest benefit to the trust beneficiaries, but also recognizing the second half of that in order to also continue to inure the best benefit, that we're going to have to actually develop the lease. So that's what the bill does. It's basically on page 2. Also very important, on section 2 on page 3, the OSOI will be defining the term qualified bidder or qualified oil and gas applicant. So that's the bill, that's what it does. Good little bill that will make some adjustments based off some concerning practices that have popped up over the past year or two. And I'll stand for any questions.
Discussion. Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I think the concept here is good, but I think there were some issues raised in the Minerals Committee as we reviewed it and with the Office of State Lands that they raised that might need to be addressed, and so I wanted to raise those in Committee of the Whole. The first is the idea that the next highest bid offer is an appropriate offer, is an assertion here. So you have a circumstance where you have some bidding going on, you have a legitimate bidder that makes a bid, and then you have an illegitimate bidder that makes a higher bid, perhaps a much higher bid, and that bid is selected. So for example, arbitrarily, we're bidding up, we reach $10, legitimate bid, and then the illegitimate bid comes in and says, I bid $100. Well, bidding is done. We'll say it's worth $50 arbitrarily, that's market. You have a circumstance where this says in a shall, the option here, the only option is, all right, the 100's illegitimate, now I go and I offer it to the next bidder at 10, which is well below market. There's no mechanism for figuring out what was the appropriate market. You could have 4 bidders. One of them's illegitimate, 3 of them were going at it, and you don't end up with an appropriate bid price. You haven't gone through a legitimate bid process. So that's one concern with the fact that the mechanism is potentially a little off, and perhaps the right answer there is to immediately let it out for an additional bid or something along those lines so that you can have a legitimate bid process take place where it was effectively illegitimate the first time. In other words, you can't just assume that the second highest bid was an appropriate bid just because the highest bid was inappropriate. That was the discussion there. The other comes down to the lines 15 through 19, any applicant whose bid is rejected under this subsection because the applicant is not a qualified oil and gas lease applicant shall be subject to a civil penalty in the amount of the applicant's highest bid. The intent there is obviously to discourage, but the due process doesn't exist. And I guess that's the question I would have. The State Lands isn't a punitive agency that is going to assess a penalty like this as if they're providing a regulatory enforcement in this circumstance. All right, well, we've deemed this an unqualified bid, so you're going to have to pay that bid. There has to be a due process associated with a decision that it's an illegitimate or unqualified bid. And honestly, that might even slow the process down. I don't think the intent is to slow it down, but you can rest assured that requires due process at this point. You can't just find somebody and then have no due process remedy for that individual. That should end up in court, assuming that it's even allowed to end up in court here, and it's even more discouraging if it can end up in court, then you don't have due process. So I don't know that this is actually consistent with the objective. I understand the interest of trying to discourage it through having a civil penalty, but the way it's structured right now, that might not be advantageous, where, Mr. Chairman, I think the real interest is to ensure that oil and gas land, state land that wants to be leased, so to speak, gets to be leased as quickly as possible to a producer that is going to bring that production forward. So those are the two concerns. We worked it relatively quickly in minerals because we were very short on time based on the schedule on this floor. We didn't address those two concerns, but those were concerns that I think are legitimate concerns that were raised and that we discussed that caused some problems in my mind. So I was wondering if any of that discussion had previously taken place or if there was any reaction from the proponents.
Further discussion? Senator Alves.
Thank you, Mr.
Ms.
Chairman.
Parrish.
Yes, the Office of State Lands raised some of those concerns and provided us with some language. And as I've been sorting it through and looking at what the regulations provide, I think the concern is how far along we let this go on in the process. What this bill seeks to do is to weed out those non-qualified bidders on the front end rather than allow them to start making these bids. And so, certainly things we can continue to work on. The way I read this bill, there's a, penalty provision, but it requires the Attorney General to bring an action in a court of competent jurisdictions. To me, that's a due process consideration that has been thought through. But as I looked at that language and visited with some of the others, co-sponsors of the bill, we just didn't feel like we wanted to adopt the proposed amendments wholesale. So, this is still a work in progress, but I think it's addressing a real concern out there that maybe we haven't seen so much in Wyoming, but we've certainly seen in other states. And so this is an important bill. I urge your aye vote, and we can continue to look at it, but it's an important one.
Senator Anderson, did you?
Thank you, Mr. Chairman. On and for the bill. This is an alarming set of events that's happening in oil and gas leases in the United States. There's a well-funded groups that want to do this and keep us from our resources. So we need to protect our resource people that they can get this. I'm sure there can be amendments to this in the second and third reading, but I encourage you to pass it on the committee of the whole. Thank you.
Thank you. Senator Barlow.
Thank you, Mr. Chairman. So I certainly appreciate the effort here and understand the outcome. Although I would say this is reactive, and maybe we should consider being proactive, Mr. Chairman, and saying you have to actually be a qualified applicant bidder before you can participate in a lease sale. So we don't end up in this situation where we're making this. So I just throw that out there for the proponents of this bill, which I certainly understand and respect, that maybe we should actually direct state lands or the board and the land and the agency involved to say, you know what, no one's qualified until they've gone through this process to bid, and we've kind of weeded that out on the front end. Thank you, Mr. Chairman.
Senator Jones.
Mr. Chairman, the fact of the matter is, we know there are people out there attacking the oil and gas industry. Our industry has asked this to protect them. The bad actors are everywhere, and if we don't come up with some way to manage this, then it's going to be out of control. So on and for this bill.
Further discussion. Senator Bonner.
Thank you, Mr. Chairman. Good discussion. Look forward to further working this bill. I do think, just to highlight the concern about trying to get, make sure that applicants or bad faith applicants, for lack of a better word, don't engage in the process to begin with. I think that's why the civil penalty is so important. But yeah, I think lots of good discussion to be had, maybe some amendments to make things a little bit clearer and, incorporating some of the feedback perhaps from the agency without, complying with this apparent expectation that we just, put their current rules and regulations in the statute. I think there's probably a balance to be found there. So hope we can move this forward, look forward to further discussion.
Ready for the question? All those in favor of Senator Cooper's motion that when committee of the whole rises to report that it do so with a favorable recommendation of House Bill 141, please say aye. Aye. Those opposed, no. Motion passes. The next bill for our consideration is House Bill 145. Will the reading clerk please read in the bill?
House Bill 145, Open Banking Amendments, sponsored by Representative Western, an act relating to banking.
Senator Cooper.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation of House Bill 145, Open Banking Amendments, and I would call on the good Senator Rothfuss for an explanation.
Senator Rothfuss.
Thank you, Mr. Chairman. House Bill 145 was worked through the interim on the Blockchain Select Committee. We didn't quite make the time deadline, so we just have individual sponsors on it. But this is cleanup of the Open Banking Act that we passed last year, and it just has two revisions that came to us from the banking commissioner, who has been working on this during the interim, developing rules and looking at what was going to happen federally. So the first change you see on page 2 is to define customer. That definition is simply compliant with the Dodd-Frank Act and with what is going on at the federal level to ensure that our Open Banking Act aligns with what is being done at the federal level. And then at the bottom of page 2 was some language that provides additional consumer protection that indicates that the participating bank shall limit the accessible customer data to that which is necessary for the customer to receive a product or service from the third-party financial service provider. So recall, there's entering into an agreement between a customer and a financial institution. This language simply says that that financial institution shall not receive or use any more information than they need to do whatever that financial service that's agreed upon is. And that explicit limitation was a further request, recognizing that we were trying to provide as robust of consumer protection as we possibly could. So it is a slight addition. That is all this legislation does. And I'd urge the body's support. Happy to answer any questions.
Discussion. Seeing none. Question's been called. All those in favor of Senator Cooper's motion that when Committee of the Whole rises to report that it do so with a favorable recommendation of House Bill 145, please say aye. Aye. Those opposed, no. House Bill 45 passes. 145 has passed Committee of the Whole. The next bill for our consideration is House Bill 93. Will the reading clerk please read in the bill?
House Bill 93 engrossed, Animal Reimbursement Program Account Amendments 2, sponsored by Representative Heiner, an act relating to agriculture, livestock, and other animals.
You've heard the reading of the bill. What is your pleasure? Senator Steinmetz.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it do so with the recommendation that House Bill 93 do pass. And for an explanation of the bill, I call on good Senator Larson.
Senator Larson, sorry I missed you behind the screen here.
Thank you, Mr. Chairman. This is a good bill. It helps our ranchers and our farmers when they have a herd that gets quarantined for certain diseases that the state vet has put a quarantine on their herd. We're raising the amount for a one-time payment from $25,000 to $50,000. And I'll give you a little bit of specifics of what kind of happens if a rancher, say, has 500 head of cattle and he has 1 or 2 or whatever gets tested for brucellosis, and they find one that's infected with it, then the whole herd is quarantined, and they test the whole herd, and they'll be quarantined for a year. And those that do test positive, I think they're probably put down. But this herd is then quarantined at the ranch. They can't go out on federal land. They can't go out on, if they have a lease with the BLM or with the forest, then they can't go there. They can go on their private ground. But so therefore they got to buy feed, and feed 500 head of cattle would cost a lot of money, like lots, especially with the price of hay. And they have to be tested at least 3 times. They have to have a negative test for the whole herd 3 times in the year. So it could go on for longer. But a specific rancher that is having this problem has definitely been beyond the $25,000 for help, and he's even beyond the $50,000. So it's critical to get some money to them so they can keep going. This isn't a disease that he got just because he was doing something wrong. It comes from the wildlife that's in the area. So I would ask for your aye vote on this.
Discussion. Senator Barlow.
Thank you, Mr. Chairman. So I served on the board that's responsible for this and many years ago. And so my question is what is the current appropriation to this account? Because this is a general fund, I believe, account. So what is the current appropriation and what is the drawdown on it been over the last couple of years? Thank you, Mr. Chairman.
Senator Larson. Oh. Senator Ellis.
Thank you, Mr. Chairman. Just a little more discussion on when the last time was the legislature looked at the $25,000 amount, and we're doubling it. That's always a thing we should be mindful of, is when we're doubling dollars. So when was the last time this was looked at? And then just any inflationary discussions you've had as it relates to this program.
Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I have a question. I think the bill's great, but I do have a question that isn't, it's just in the existing statute, but I was curious how this is working as we're looking at the history of it. The existing language indicates that no payments from this account shall be made when the account balance drops below $100,000. And you may not know this, since this wasn't necessarily the target of the discussion, but I'm really curious about why there's $100,000 of what is effectively frozen money in that account that's inaccessible. And it's probably been that way for a decade or 2 decades or something like that. It seems like that would be a good little bit to change while this bill's up as well, so that that's unfrozen dollars. There seems to be no reason for it, unless I'm missing something in a paragraph above or below, why that $100,000 should be reserved for some other purpose. So what is the purpose of the frozen $100,000?
Okay, we'll go to Senator Larson to answer those questions.
Mr. Chairman, I'm going to have to phone for help on some of these. On the first one, I can't answer that one. The account balance currently is $551,000. The past 2 years, we heard in testimony, they paid out in the past 2 years $50,000. So that gives you a little bit of information there. On the other two, I may have to call for a little bit help.
Senator Steinmetz.
Thank you, Mr. Chairman. This is an account that was set up in 2012. I'm not sure on the frozen funds. That's a very good question. We'll ask about that, why that is. Again, there is $551,000 in the account right now. We do have at least one herd under quarantine and possibly more coming. And $25,000 is just not adequate. When someone has to, obviously this herd that's under quarantine can't be out grazing. They may have to purchase hay. They may have transportation costs. And these, a lot of times, are caused from contact with wildlife, with a producer has no control over. So we just feel this is a prudent use of funds, and we'll try to get an answer for you on the $100,000. Thank you.
Senator Kolb.
Yeah, thank you, Mr. Chairman. To add to the conversation, the harsh winter we had last year pushed the elk down, and they commingled with, in this case, these herds. And that is what's caused the huge uptick in the brucellosis and trying to deal with this. So that's really what happened currently, which really changed a lot of the funding need, was the weather and elk. Thank you, Mr. Chairman.
Further discussion? Questions? All those in favor of Senator Steinmetz's motion that when Committee of the Whole rises to report, that it do so with a favorable recommendation of House Bill 93, please say aye.
Aye.
Those opposed, no. House Bill 93 is passed Committee of the Whole. The next bill for your consideration is House Bill 75. Senator Hicks.
Mr. Chairman, I move the Committee of the Whole. Mr. Chairman, I move the Committee of the Whole beg leave to rise and sit again.
Pardon me? You've heard the motion. What is your pleasure? All in favor say aye. All opposed, nay. Thank you. Motion passes. We're resting from committee of the whole.
You won't like the ones I want. We have a committee report read in, please.
February 29, 2024. Mr. President, Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 104, Omnibus Water Bill Planning, respectively report same back to the Senate with the recommendation that it do pass amended. Ayes, Senators French, Hicks, Ide, Kolb, Larson, and Steinmetz. Senator Steinmetz, Chairman.
Thank you, Randy. Mr. Majority Floor Leader, Senator Steinmetz.
Thank you, Mr. President. When I asked that House Bill 104 Omnibus Water Planning be re-referred to appropriations, it hadn't been read in yet, so I would respectfully request that that be re-referred to appropriations now.
Without objection, so ordered the second time. Senator Kinski.
Thank you, Mr. President. Your Senate Appropriations Committee Number 2 on Friday, March 1 at 8 a.m., State Capitol Room E301 and online, to hear the re-referrals of HB 104, Omnibus Water Bill Planning, HB 43, State Forestry Good Neighbor positions, and all other referrals and re-referrals as assigned.
Thank you. You'll have to do that one more time. Senator Hicks, that clears the desk.
Mr. President, I move that we stand recess until 2 p.m.
Announcement, Senator Kinski. Same announcement.
We have to do it over.
Sorry. I'm ready to go.
Your Committee Number 2 on Friday, tomorrow morning, 8 a.m., room E301, to hear HB 104 Omnibus Water Bill Planning, HB 43 State Forestry Good Neighbor positions, and any other re-referrals as assigned.
Senator Baldwin.
Thank you, Mr. President. Your Committee 10 will meet tomorrow morning, 8 a.m. to hear House Bill 24, Certificate of Need and Repeal, Room 6 and online.
Senator Biden.
Thank you, Mr. President. Your Committee Number 3, Revenue, will meet upon noon adjournment in Capitol Room W6 and online to take up the following House bills. House Bill 3, Engrossed Property Tax Exemption for Long-Term Homeowners, House Bill 4, Engrossed Property Tax Refund Program, and House Bill 45, Engrossed Property Tax Exemption, Residential Structures and Land. And if we need to, we have the room reserved upon adjournment in case there's any carryover.
Thank you. Senator Schuler.
Thank you, Mr. Chairman. Senate Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources will meet tomorrow, Friday, March 1st at 12 o'clock p.m., not our usual time, noon, to take a look at House Bill 60, Excess Wildlife Population Damage Amendments.
Senator Cooper.
Thank you, Mr. Chairman. Your Judiciary Committee Number 1 will meet tomorrow, Friday, March 1st, 2024 at 8 a.m. in the Capitol Extension Room, W004, and online to consider the following bills. House Bill 29, Engrossed Cold Case Database and Investigations. House Bill 58, Forensic Genetic Genealogy Pilot Program. And House Bill 77, Engrossed Simple Assault Menacing.
Senator Kinski.
As a point of information, your Joint Conference Committee on the Budget Bill will be meeting at 12:30 in E301. Thank you, Mr. President.
Point of order, Senator Hicks. What time did you tell me to come back in? 2 o'clock. Thank you very much. Heard the motion. All in favor, say aye. Aye. Those opposed, no. Senate will stand recessed until 2 p.m.